Well, hello everyone, and welcome to the Tenpenny Files. I'm your host, Dr. Sherri Tenpenny. The Tenpenny Files is a daily conversation meant to inform and to educate, not just to entertain. I come prepared and we let the discussion unfold naturally with people worth hearing on topics worth exploring. If it matters to your body, your freedom, or your future, we talk about it here. Each day, I talk with authors, documentary filmmakers, and independent thinkers whose work challenges mainstream messaging. We cover a wide range of topics from government, politics, and history to food, fitness, and travel to astronomy, pets, and vaccines and health policy. We cover conversations every single week with authors who write about faith and biblical principles. The goal is to introduce you to topics you've never heard of before, or topics you always wish that you wanted to explore, but you didn't know where to begin. Let our guests show you the way with their books and their films. Join me here every day, Monday through Friday at 3 p.m. Eastern on the Tenpenny Files, as we hear from voices that have been ignored, censored, or silenced, but truly have something important to say. Before we begin today's episode, I just want to encourage everyone to join us. Become a Tenpenny Prime member. It supports what we do and gives you a great additional amount of education with recorded content, a monthly white paper, and a great Ask the Expert masterclass that we do every month. And every month we think it's the best one until the next month. And then we say that one's the best one. Well, this is part of your membership. We hope that you'll join us. Go to primemembership.drtenpenny.com to learn more and support our work, and come and join us. We have a lot of fun over there. So now let's get started. Today's conversation, I have two guests today. One is Dave Howard, who is a minister, a state representative, and a state senator for 13 years from 2009 to 2022 for the great state of Montana, and James Rigby, a retired Seattle attorney who practiced bankruptcy law and has 40 years of courtroom experience, to talk about their co-written book, The Supreme Court's Confidence Game, The Lie of the Judicial Review, The Theft of Power Control from We the People. The book that pulls back the curtain on the courts have redefined their power and have done all of this without voter or legislative approval. And the book really does tell you exactly in common language. It's not just written in legalese. It really does tell you what the heck's going on. Gentlemen, what the heck is going on? Welcome to the Tenpenny Files. Tell us all about that. What's going on with the judicial supremacy?
Well, I'll start. Like just today, okay, I got a news thing that said that appeals court sends a message to an anti-Trump judge by slapping down constitutionally suspect ruling. Essentially, what this judge did was told President Trump, his ICE people, what they could have as far as weapons. They mandated whether they had to have tear gas, whether they had body cams, or requiring visible identification for agents. Okay. And what the court did is slapped it down. Well, how did this judge come up with this when he doesn't have this power? And what we did is we wrote this book, okay, The Judicial Supremacy, the Supreme Court's Confidence Game, because they're running a confidence game. These judges are operating way out of their territory. They don't have the responsibility. They don't have the authority. And the problem is they keep still making decisions that are unlawful.
I've wondered about this. I think a lot of Americans have wondered about how a unnamed judge in an unnamed jurisdiction. I remember one judge was in Illinois that did. She was a judge over like traffic tickets, and yet because she said, Trump, you can't send people to out of this country, you can't deport them. And suddenly, he had to shut down everything because of her. And in his first administration, it seemed to be nothing more than a series of judges, legislative, and making rulings from the bench. Let's get right to the heart of your book. And what is the confidence game? James, maybe you want to tell us what that is.
Confidence game is a game that judges play. They gain our confidence And the way they gain that is by putting on a black robe and sitting in a chair higher than where we in the courtroom sit or stand. And then they give us a ruling. And the rulings that we're talking about here today, there's no basis in the law for these rulings. But since we agree to perhaps too highly respect the judges, and since we agree that they are the courts, we accept their rulings. And this is wrong, wrong, wrong. We should go back. We need to go back and look at a little bit of history here and see what the legal history is, because like frogs in a pot where the heat slowly comes up, the American public has been boiled to the point where they don't really understand what power judges have, what powers they do not have. And as Senator Howard said, we're seeing this play out every week in the news. Some judge is telling the president to do something. And the fact is they have absolutely no legal authority to do that.
And that's the truth right there. They have no legal authority.
Why is it that everybody believes them and believes that because they're a judge, they do have the legal authority to do that?
The Constitution lays out our government, and it lays out three different branches. Everybody knows, I think, there's a Congress, there's a president, and there's a judiciary. And the judges have the constitutional authority to make a ruling on a case. If I get a traffic ticket and I contest it, I can go in and the judge will decide whether or not I was speeding based on the evidence. The judge does not really have the authority to tell the police that they can only put up their radar in certain places and they can only use it on certain days, and that they need to fly a flag of some sort from their police car when they're doing that. Judges have no authority to make those kinds of rulings. And that's essentially what we're seeing today in our country, and not only nationally, but locally as well. The judges are out of control. They jump the fence. They have no legal authority to do what they do. For instance, the judge that Senator Howard just mentioned issued an injunction, I think, against the president. The district courts have no legal authority. There's no law that says that the district courts can enter an injunction against the government from doing something. If the government brings somebody into court, the judge can say, well, that law is unconstitutional, and so we're not going to enforce it. They have the power to do that. They do not have the power to tell the government, how it can act and what tools they can bring to the riot. The judges are just totally and completely out of control. I think it would be helpful if we went back and started at the beginning and kind of laid this out for the listeners, because what I'm saying, without the background that Senator Howard and I developed researching the book, without that background, what I'm saying sounds pretty silly, because of course a judge wouldn't go outside of his legal authority to issue a decision. We're seeing it every week, if not every day.
And answer your question when you said, how is this happening? The reason it is happening is we've heard the old statement that knowledge is power. Well, what is ignorance then? Ignorance is truly unlearned. We have a populace in America that is ignorant of their own Constitution. All right. They don't know what's in it. They don't know what power a judge has. And what happens is when, like James is talking about, you go back and you start, like I was a representative, and I was seeing these judges do something nationally. I mean, look at the most egregious decision, Roe versus Wade. Okay. Now, can judges make law? Well, how did Roe versus Wade become law? It's through literally ignorance. And also, too, the people that have the power to overrule this is our legislature, and also in Washington, D.C., our Congress. Are they capable of doing anything? I sometimes wonder. So when you're looking at this, you're looking at a process where the judges are completely fabricating their authority. And it's true. They're fabricating. You got to look at a con game has to lie to you, or they can't get what they don't deserve. They have to convince you that they have authorities that they don't have. That's what the judges are doing today. It is nothing more than a con game. And it's because we are ignorant of the law and our legislatures and our Congress doesn't have any backbone. And that's the bottom line right there.
Well, this concept of judicial supremacy, when did all of this start?
Well, it actually started, as best we can tell. Actually, you can say it started in 1803 when Chief Justice Marshall made a decision. He made a decision on a case of Marbury versus Madison. Then you go fast forward to like 1959, and you have the Warren Court using that decision, literally fraudulently, to tell the people that because of that decision, they now have this authority, okay, judicial supremacy. Now, think about this. How is it that we change our laws in our Constitution? In the Constitution can only be changed by an amendment to the Constitution. Then how did the Warren Court create an amendment in their own mind and then tell the people they have this authority, and then every judge after that claims it? That's kind of what has taken place. And James, would you like to comment on that?
Sure, I would. I mean, if you go back and look at Marbury versus Madison, what the court ruled there was that the Marbury, the person before them bringing the case, brought the case based on a law that Congress had passed. The court said that, well, Congress, that law violated the Constitution. So the court could not rule in Marbury's favor because it did not have jurisdiction, because the law that Congress passed, the court said, was unconstitutional, period. That's the end of the case. It's a fairly narrow ruling. It says the courts can ignore a law or should ignore a law that Congress passes. And when Congress passes a law, they have a duty to ensure that the law is constitutional. But the judges are not bound by that. They need to investigate the law themselves. And if they come to the decision that the law is unconstitutional, well, then it's not effective. But you go to 1958 in Cooper v. Aaron, what the court said was, it said, well, here's the constitutional amendment, and this is how we interpret it. And since we, the court, are the supreme law of the land, that is the supreme law of the land. Now, that quote saying that we are the supreme law of the land is totally incorrect. The Constitution says, and it's Article 6, the Constitution, the U.S. Constitution says that the Constitution is the supreme law of the land. It does not say that the judges are the supreme law of the land. And in our investigation, I mean, that's Marbury's really being miscast. It's being intentionally misread and intentionally misrepresented. And that sounds kind of harsh, but in about 1970, rather in about early 80s, excuse me, President Reagan's Attorney General, Edmund Meese, wrote a paper. And he wrote the paper on Aaron v. Cooper, rather Cooper v. Aaron. And what he said was that the Cooper court misread Marbury versus Madison, then it misrepresented Marbury versus Madison. And in the Attorney General Edmund Meese's words, when the court said that they were the supreme law of the land, that the court was making war upon the people and upon the Constitution and upon the Congress.
Right.
And if you were to look at the law of treason, which is pretty harsh statute, penalties are anyhow, it says making war against the United States is treason. And so that's what the court did in 1958. And, you know, for us, two unknown persons from way out west in Montana to accuse the Supreme Court of treason. That sounds pretty outrageous, and it might even be funny. But the fact of the matter is, the Attorney General under President Reagan, those are his words. And what's happened since 1958, the courts have a habit of saying something outrageous in a case and then let it lie for a few years. And there's no blowback on it. Everybody ignores it. Nobody talks about it. But then at an opportune time, they will quote that language and treat it like the foundation of the world. And it's not. The language is false. I mean, it's totally 100% wrong. But that's where the courts are at now. They claim their power of judicial supremacy through this Aaron case. And they will to cite back to Marbury versus Madison and say, well, it's been long respected and long followed. Well, that's a load of baloney, because it was on that point ignored until 1958. Well, 1958 is probably before most people who hear this broadcast was born. But the fact of the matter is, current courts claim that they're the supreme law of the land. That's wrong. It's insurrectionist, it's treasonous. And those are very harsh words that, again, can sound comical, but the fact's a fact that they don't have that authority. So, Senator, do you want to come in here?
Well, the key thing is this: what they use is great words. Okay, they use things like precedent. That's what James was talking about. Let me pull precedent down to something that every one of us that is listening can understand. Let's say that you have a preacher, okay, who quotes. He tells you that he's quoting the truth, but he's not quoting the Bible. He's quoting another preacher. Okay. And then that preacher quotes another preacher, but they never quote the Bible. In all of these decisions, Marbury versus Madison, the Warren Court, all of those, they never quoted the Constitution. Never once. They quote another case. That gives them the ability to circumvent the Constitution, because most people listening to it are not learned enough to know what they're doing. They're lying to us. And they're doing it because they either have a political agenda or some other kind of agenda. I mean, what could possibly be the agenda of this judge trying to tell the judge, I tried to tell the President of the United States how ICE is going to operate and even what equipment it's going to have. He doesn't, you see, he knows that's a lie. He either, if he doesn't know it's a lie, he shouldn't be on the bench. He's supposed to be an expert of law. You see, that's why this is the worst con that you ever seen in your life. And for our Congress and our representatives in states not to represent the people and stand up for this is egregious. And we should unelect them.
But I think that the general public, I'm just listening to this conversation through the eyes of just John Q. Public, somebody that's got, a college degree in marketing, or is an engineer, or is maybe just graduated from high school and didn't even go to college, that they're listening to this. And I think that most everyone thinks what the Supreme Court says is the way it is. And that's why every time that you have a difficult case and it doesn't go your way and you make an appeal, you appeal to the next court and the next court and the next court. And if it gets to the Supreme Court and they're willing to hear it, which I've always thought was really a dicey thing, that they get to pick and choose what they think is worthy of hearing. But when they get to the point of hearing it, whatever their decision is, that's the final say, with like, okay, this is the final to say, but how does that play up against the Constitution? That nobody ever asks that. It's just that they make the decision and then that's the law. And I think that that's the way we interpret that. Is my interpretation correct in the way that I view it? And at the bottom line, is that interpretation wrong?
In reality, how it's supposed to really work is a Supreme Court judge makes a decision on the law, and the Congress has to change it, and the president has to sign it. Otherwise, nothing's changed. You see, what we don't understand is that, and this is why everyone should read this book, is the fact is this: the Supreme Court's like a referee in a baseball game, but he doesn't have the authority to enforce his call. So if you had the legislature in the outfield and the executive batting, and it looked like it was a foul ball, and the judge, who would be the referee, says that's a foul ball, he has to get agreement with the president and the legislature before it becomes a foul ball. He has no authority. And I mean, right from the beginning, what it is what was it Hamilton stated in Federalist 78. The Constitution gives the judicial branch neither force nor will, but merely judgment. Merely judgment. What is this judge doing? Is trying to tell Trump how to run ICE.
Though, I mean, Trump has access to hundreds, if not thousands, of attorneys. He's got his personal attorneys, his business attorneys. He's got the Department of Justice and their 1,000 of attorneys. And he's got, however many other ones he wants to hire, either as the chief executive of the country or just because he's a billionaire and he can spend a lot of money. I don't know, but he has access to lawyers everywhere. I mean, why is it that no other lawyers recognize the FUPA of the court's judicial supremacy and calls foul on that?
Well, let James answer that, because it's fear.
Well, it is. I suspect that President Trump understands the situation as we lay it out. I expect that his team of lawyers, or many of them, understand the situation as we lay it out, but it's political also. If he was to say, well, I'm not going to follow this decision, then he's got a big political pushback on that. And he's got a battle to fight, a separate political battle to fight. And as kind of the softly boiled frogs that we all are, the reaction is going to be, well, President Trump doesn't have that authority, because during our lives, the presidents have not pushed back against the court, but the courts become more and more aggressive as time passes. So part of what's going on, I think, is an attempt to educate, by President Trump, is an attempt to educate the public. And from a practical standpoint, you can't have, district court judges. There's hundreds of them in this country. You cannot have a committee of 100 disjointed judges deciding how this country is going to be run. That's from a practical matter. From a legal standpoint, there's no statute, there's no law that says that the U.S. district court judges can enter an injunction against administration. It simply is a bad habit that got started, and it's gotten worse and worse and worse.
Boy, I would agree with that, calling that a bad habit if it's not even or judicially correct. You say in your book, the Supreme Court's confidence game. It's just the title of your book, the Supreme Court's confidence game. That when judges from the bench rule from the bench, they violate 6 clauses of the Constitution with no accountability. Why have both the federal and state legislatures been negligent in checking and counterbalancing the courts?
Senator Howard, you can answer that to begin with.
Well, the thing is here's the truth about serving in the legislature. Most legislatures, unfortunately, run through this. If I vote for this, am I going to be able to get reelected? Also, too, most legislatures, and I have to say I served for 14 years. In the first 3 or 4 years that I served, I had no idea of what I'm telling you right now. In Montana, they supposedly have a 2-day law class. but they never taught us anything about what we're talking about. They never told us that the Supreme Court is only can make judgment. And if you look at some things that we showed you in the book, and people should read the book and show how just absolutely fraudulent Montana's Supreme Court is, and we're not alone. There's probably another 30 to 40 out of states, okay, of Supreme Court justices and Supreme Courts that are acting beyond their authority. But remember, I said, knowledge is power. That's why we wrote this. We want the common man, the common person, the doctor, the carpenter, whatever you are, to be able to read something and have it documented to the point that you know what they're doing. That is going to change our country. Because if I was President Trump, and I can't speak for him, but if I was President Trump, the Supreme Court has already made some of these decisions that they cannot make these. The lower courts can't make these decisions. I would tell the public that this judge is out of line, he's unconstitutional, and I'm not going to abide by that decision. And I'm referring it to the House of Representatives to have the man or the judge impeached. That would put it on the forefront, okay? But as James said, if we don't fight back, what they are right now, they're essentially won the battle.
I'd like to join in
Sure.
a little bit at this point. And, what can people do goes through their minds? Because so many people, we all see a problem. Well, that's out there. That's away from my house. There's nothing I can do about it. Well, to a great degree, it's true. But I think by people reading our book and understanding it, it's just clear as can be once you go in and understand it. And I should say, I did not know this when we started. Senator Howard and I were working back and forth on a couple of things, and he kept bugging me to look more at this, and it took him quite a bit of bugging to get me to look at it. It was 3 or 4 times he asked me to go look at Marbury versus Madison, and I read it all on the phone. Yeah, it says what you think it's, it says what everybody thinks it says. And then maybe the 4th time he called, he gave me a link to a law professor, Michael Stokes Paulson, did a continuing legal education seminar in about 2004, I think, somewhere in there. And the law professor, he went through Marbury versus Madison, and he really broke down the case legally and explained that everything that's claimed about Marbury today is a myth. We think we know something, so we don't go look at it. And I will say that it takes, once you take a look at Professor Paulson's analysis of the case and go back and read it, it's like, holy cow, how did I miss this? I mean, it's as simple as it possibly could be from a legal standpoint, but we've all been conned to think something. So when you read a case, me included, you have an expectation of what it says, and you read that into it, and you kind of, when there's illogical steps, you just kind of jump over one illogical step because everybody knows that's how it is, and you just keep moving on. So people need to be educated. They need to educate their representatives at the state and federal level. The judges are wrong. I mean, Congress can impeach judges, and why don't they just simply pass a law that says district court judges do not have jurisdiction to issue injunctions against the United States government? A dozen words or something. They could do that. Now, the courts don't have that authority now because there is no statute, no writings by Congress signed by the president, no law that says that the courts can enter injunctions against the government, yet they do. The courts are there to rule on a case or controversy, going back to about 4 questions back. When somebody takes a case to the Supreme Court and they get a ruling for the 2 parties, at least in that case, that's the end of it. That's the final ruling. But it does not bind Congress. It does not bind the government. It does not bind the voter.
Wow. Well, hold that thought right there, both of you, Senator Howard and also James, because we got to take a really short break. We're a little past our time here, so we'll have to rush through this a little bit. because this information is so vital to what's happening in our country right now. And people really need to get this book, The Supreme Court's Confidence Game, and read it and study it because it's really about our lives. So we're going to take a really quick break here to hear from our sponsors of AmericaOutloud.news. You can listen to the Tenpenny Files daily, Monday through Friday, Eastern Time on iHeartRadio and AmericaOutloud.news. If you've missed any of these great conversations, you can find them on Spotify, Pandora, Apple, iTunes, and on my platforms, drtenpenny.com and drtenpenny.substack.com. We'll be right back with more from Senator Dave Howard and James Rigby to talk about their really important co-written book, The Supreme Court's Confidence Game, The Lie of Judicial Supremacy, The Theft of Power and Control from We the People. Sit tight, we'll be right back. Zeolite is a detox spray. We work specifically with a company called Touchstone Essentials. They are an incredible company. We've been working with them now for several years. And zeolite is a mineral that goes through your body like a one-way basket. It will clean out heavy metals such as arsenic and mercury, aluminum, cadmium, and it hooks onto those metals from a one-way perspective. So once it's bound, it goes out through your urine or your stools and doesn't get redeposited in other places. Everybody needs to have a detox product in their life, and this one is so easy to use and it's so safe. You can take it when you're pregnant, you can take it when you're nursing, you can give it to little children, you can even give it to infants, and quite frankly, I give it to my dog. I actually put a little bit of the zeolite in his water because until we all stop living in a toxic world, we all need to get some of those extra toxicities out. The heavy metals, the persistent organic pollutants, the things that are floating through the air, the different things that we come in touch with in our environment. And we are a big fan of zeolite from Touchstone Essentials. We've been a big fan of their products for several years. Go to drtenpenny.com/detox to get your first bottle of zeolite spray for $50 off.
Well, only when the government bows to the people will America become great again. This is Malcolm Out Loud here. Join me in pushing back against censorship, my fellow Americans. Right at the top of AmericaOutloud.news are the words: many voices, one freedom, united in the First Amendment. Now is our time, my fellow Americans. AmericaOutloud.news, liberty and justice for all.
Well, welcome back, everyone. Senator, let me just tell you a little bit more about today's guests because they have the power to write this and they know where they're coming from. Senator Dave Howard is a returning guest to our show. He holds a master's degree in public management from DePaul University and a bachelor's degree of criminology from California State University, Los Angeles. He's a minister and founder of Foxhole Ministries, the creator of a national radio program, The Voice of Truth's Wake Up Call, which is broadcast daily in at least 25 states nationwide. Dave is also a U.S. Army veteran, Vietnam veteran, and a former FBI agent, and you can spend the rest of the show reading all of his long list of credentials. State representative and state senator for 14 years from 2009 to 2022 in the great state of Montana. James Rigby is a retired attorney who practiced bankruptcy law in Seattle, Washington for 40 and has 40 years of courtroom experience from 1980 to 2020. His family has made Montana their home since 2014. Gentlemen, welcome back to the show. I wish we had a couple of hours to dig into the very much details of this book because it's written to the common person and it's foreign to our brains. It's just foreign to everything we learned in high school and college and learned on the streets of about how this kind of acts we hear on the news. You know, a judge has sanctioned the president and said he cannot do this and he cannot do this, but yet he can. Can the executive branch can the U.S. president rule by executive orders, kind of like how he's been doing?
Yes, he can. The thing is that I want to make a comment about our book just really quick. One of the things that made James and I really work out and be able to write this book was that I came from an investigative standpoint. He came from his attorney background. Okay. So what happened is that when he was talking about Marbury versus Madison, I was saying, okay, they say they got judicial supremacy, so I take the decision of Marbury, okay, our the Supreme Court justice, and I'm starting to go through it. Oh, there's nothing there on it. There's nothing there. There's nothing there. There's nothing there. And I go all the way down to the last part of the Marbury decision, and actually he supports the Constitution and the authorities in the Constitution. He even says that any law that is repugnant to the Constitution is not law. Well, what the court did in 58, the Warren Court, was repugnant. And so I kept going to James and saying, wait a minute, this is what it says. It doesn't say this, and it doesn't say, and James kept looking at it again. And then I found that the attorney that did the program on Marbury versus Madison, and I sent it to James. He nailed it. The whole idea of Marbury versus Madison is a fraud.
You know, I asked you gentlemen about this book on my previous show on my other platform when we did This Week with Dr. T. And I believe, James, you told me something that rung in my ears for a couple of years since you've been on the show, that most law students and most practicing lawyers have never read the Constitution.
That's right.
Is that true? And
Let's say they don't study most of them have not studied the Constitution. In law school, you're learning to be a lawyer. So you read cases, and you read cases about the Constitution. And for instance, you could read Roe v. Wade and say, wow, yeah, well, I don't understand it, but they're smarter than me. They've got the black robes on, so they must know the right answers. And so that's what they did. The law school does not give students a copy of no class, or very few, you have a copy of the Constitution and say, okay, and read this. And here's the writings that occurred at the time the Constitution was written, such as the Federalist Papers. There's a massive amount of writings that were generated, particularly before, during, and after the Constitution was adopted, saying what it says, explaining what it says. Law students don't really care about that because they want to go out and practice law. And by the way, they don't really generally want to go out and challenge the Constitution. You know, they want to know how to handle a car wreck or a medical malpractice claim or a traffic ticket. And so there's really no study of the Constitution as such. And it's rather amazing because it does not give the law students don't have the right frame of mind when they come out of law school to then look at cases as, are they constitutional? Well, there's no money in chasing that question for lawyers. And that really is what you're there for, is for the small case and to try to make a dollar like everybody else is trying to do. Well, you know, having retired, I have the benefit of spending my time where it's interesting. And Senator Howard is nothing if he's not interesting and have interesting questions. He cornered me, and we worked on this. And you know, I just went through this like I would a case. Somebody comes into my office and here's the facts, here's what's going on. I mean, on occasion I would say, well, I don't know anything about the law in that area, but I'll go look at it. And that's what I did as a generalist, looking at the Constitution and looking at these cases. These cases do not jive with the Constitution. And we've got proof of that from the Dobbs case of 4 years ago. The Dobbs case said the Supreme Court in Roe v. Wade was blowing smoke. I mean, it's that Roe v. Wade thing was a con on the American people. It was a confidence game run on the American people. That case was accepted because the American people respected the Supreme Court justices. In fact, they could have been impeached for issuing that decision because no basis and Dobbs, the Supreme Court 4 years ago, said there's no basis in the Constitution for abortion. It's a total fabrication of somebody's imagination. And that's, go ahead.
And look at the consequence. 60 million people, young, unborn babies, are murdered because we won't stand up to 9 justices that are fabricating the law.
Let's take another recent case and apply your concept here that you talk about in the Supreme Court's confidence game. The most recent ruling against President Trump and tariffs, for the Supreme Court to say it's unconstitutional and you can't do that. And then basically in Trump's press conference, he said, I think I can, and I'm going to do it. And was he right or was he wrong?
Well, he was right because of the fact that he's using other laws that is already on the books. And what's interesting is that very thing that the Supreme Court looked at, I think it was like during Nixon's time or something, the Supreme Court had looked at it and was totally constitutional. Okay. So he's using other laws to get what he needs to get done. Okay. But there's so much politics played in this process. And that's why the judges should just, it's like, James was saying, in the state of Montana right now, for an attorney to go through school, they do not take one class on the Constitution.
So of course, James, I mean, like when you go to medical school, take a course in anatomy, physiology, biochemistry, etc. And in law school, isn't there a constitutional law course that you have to take?
Yes, it's the case law of the Constitution. In the constitutional law class that I took a few years ago, and it's probably the same darn textbook today. I know it's not the case, but they're studying the cases that the court has issued. And they're not studying really what's the foundation for the case. Where does it go? What is the basis of it? I'm sure they're going to look at a phrase in the Constitution, but go back and read what the writers of the Constitution meant with that phrase. Things have been changed so much. I mean, we're slightly boiled as a society, and we're frogs that have been boiled. We've been pasteurized. We take what the court says at face value, and we don't really go back and think clearly about it. But that's really beyond the scope of 99.999% of the lawyers to take those constitutional issues up. I could turn the question back on you a little bit mischievously. I mean, how much time do doctors in medical schools spend studying vaccines?
Like none.
Excuse me?
How about nutrition?
Was that none?
None.
None. Well, but they read their emails that say this vaccine will take care of this problem, and we got people all the way across the country get the vaccine. So it's a little bit of the same thing. People are too used to saying, well, the doctor knows, the lawyer knows. Stop and think for yourself. You're responsible for yourself and what you do, and you need to understand what's going on. And if you want to understand what's going on with the laws in this country, you need to go back and look at the Constitution and read about it and think about it. And then when your local congressman or legislature has a local get together with the voters, you can ask them, what are they doing? Why hasn't Congress passed a law saying these judges can't do this? Of course, there's no law authorizing them to, but it would be a big roadblock for the judges if Congress were to do that. I think there's been a political game played over the years where if Congress doesn't want to do something, they'll toss the ball on the court, and the court like abortion that was legal in New York State at the time of Roe v. Wade, 1973, and maybe one or two other states, but not at all across the country. It would have been shot down if the legislature would have dealt with that directly, or even more recently, on homosexual quote unquote marriage, which is an oxymoron. But, that was imposed by the courts. I mean, yeah, I think California voted against it, and the Supreme Court there threw it out, and a few years later, maybe they voted for it. Washington State, my home ground, probably voted for it, I think. But that was basically imposed by the courts. So you have this political game where you get some issue that's too hot, the legislature throws the ball in the court of the courts, and the courts aren't elected, so they go ahead and make a ruling the legislature wants, and the legislature can say, well, I'm sorry, there's nothing I can do about it. That was the courts. Baloney. The legislature can impeach those judges for making unconstitutional decisions. They didn't want to for so long that we've forgotten we have that authority. If I bring up to a Montana state legislator that you're grousing about these clearly unconstitutional decisions that the Montana Supreme Court is making, and yet you won't vote to impeach him. Oh, we can't impeach him for that. Well, yeah, you can. If a judge is so incompetent, he doesn't know what the Constitution says, it's out. He can get tossed out. He can be impeached. We're out of the habit. I mean, before I want to use the word habit in terms of judges are in the habit of issuing injunctions. I mean, in a way that's true. It trivializes it. It makes it seem like, well, it's not so important. But if I jump up and down and say, well, that's treason and they should know it, that's maybe seems a bit on the harsh side. But everybody needs to kind of tool up, figure out what's going on, do some research. I mean, you must be telling your listeners when it comes to vaccines that you really need to research what it is you're contemplating taking and what the effect might be. Senator.
Yeah. Well, the thing is that's why we wrote this book. Okay.
Yes.
It is the real reason. It's because I came into this as a legislature ignorant about my own constitution and on the Montana Constitution. And then I was watching these judges do things. Okay. Like, for instance, I'll tell you a real short story. I was able to pass in the legislature to get on the ballot that in Montana, Montana could not give illegal aliens benefits. Our own Supreme Court threw it out because in the law, it said that it made the term illegal aliens. Our court was so egregious that it said nowhere in law is the term illegal alien. They must have forgotten to read Title 18. That's the criminal code. It's all through it. Okay. That's how egregious they are. Okay. They're controlling this state. And if you want to know how they're doing it, then you want to get this and you want to take a look at it and you want to read it and you could actually study it. I wish that this would get in some classrooms. I tell you what, our legislators couldn't ignore the law and stop doing their job if we knew what they were supposed to be doing. That's the key.
Well, we've got just a couple minutes left with our time here today. I want to hear from both of you about what we can do to get this information into the appropriate hands to do something about it. Dave, why don't you go first?
Yes. We've touted the name of the book, but the only place you can get it is on Amazon. So I'll say Amazon. That's where you go and get it. It's $15 whole. It's about 3 cups of coffee for the book. And once you've got it, and I would interject, it's worth buying if for no other reason, is that we incorporate one chapter is a reprint of Attorney General Edmund Meese's article on Cooper v. Aaron. So if anybody thinks that maybe I'm slightly exaggerating what he said, he uses the word war, I use the word treason. They're analogous in that context. But he says what we've been saying. You need to get the book, you need to read it, you need to hold your legislators' feet to the fire. Do they know? Do the legislators, dollars to donuts, very few of them understand the situation, but they need to understand it and then they need to act on it. When judges are acting outside of the fence, they need to be impeached. It's not a big personal thing. It's just you ruled against the Constitution. You need to go find a new line of work.
Dave?
Yeah. And I think that I said it earlier, knowledge is power. This gives us knowledge, okay? So we can talk consciously. We know what kind of fraud they're committing. And then Just think about it. We know how good word of mouth goes, and it goes really well. And then you get your legislature one of these books and you send it to it and you say you want comments on it. And then you get it as we're involved in the political in it, you have central committees, you have all that type of stuff. You start speaking about it and telling how big of a problem is. And then you can use, like today was that information about that judge that got overruled because he was unconstitutional. You can pick one of these up almost every other day. Okay. It is happening. Okay. And really they're out of control. And our Supreme Court isn't doing it. Our Congress can do it, but there has to be the will to do it.
Boy, I think that's the bottom line, the will to do it. And I just, you made a comment in passing, Dave, that, does our legislature do anything? And I think that we, the people, would generally say no. And so I think that getting a copy of this book is really, really important. In fact, for $15, you ought to buy 5 copies of this book so that you can hand it out to your local legislators and people that you know. I mean, all of us have lawyers that are friends,
Sure.
are activists and are doing different things. We can send a copy to them and say, listen, spend 3 hours reading this book because it reads fast and it's written really very well. And it's written to the non-lawyer mind so that you can and really comprehend it and get it into your mind. The subtitle here, The Theft of Power and Control from We the People, kind of says it all. And so we made all of these books available at our store. That's bookstore.drtenpenny.com. So people can go there. So it's an easy place to find it. If you forgot the name, you could go into the store and you can look around. You could find it right there. Because for those that are watching, you've seen the cover of the book. And in fact, the back cover says A Legislator's Guide to Reestablishing Our Constitution, which should almost be on the front cover because it's so good. Thank both of you here for being here. Thank you for taking the time to write this, and thank you for even more for being on our show today and taking the time to explain it. So I want to thank all of our listeners who are here that I know you will go get a copy of this book and send it to your legislature, and you sit down and read it too, because everybody's got a school board, they got a city council, they got all sorts of things. You vote for local judges. You need to know how to hold their feet to the fire. So with that, I'm going to close with one of my favorite verses from the Bible. I close all of my podcasts with, whether it's live or pre-recorded, which is Romans 12:12. Rejoice and hope, be patient in trouble, and be persistent in prayer. Lean into God. He will never let you down. Even though his timeline may not be your timeline, he's always there with you. So I will see you every year tomorrow or the next time on the Tenpenny Files. Bye, everybody, and God bless.